Let the record reflect that 3 members of the hearing board are present at the AQMD headquarters and 2 members are remote at the same location, which was properly agendized, and the location is accessible to the public at the present time, but there's no one in the room to provide any public comment and or to witness the proceeding. Madam Clerk, did anyone sign up to provide evidentiary testimony or just general public comments?
No, we have no one that signed up or online either.
Thank you. Let the record reflect that no one has sought recognition to provide any public comments with respect to matters that are on the agenda. We will now move to case number 6229-2, an interim variance, which is on consent calendar. There are multiple exhibits. The petition was filed by the County of Riverside. The first exhibit would be stipulation to place the matter on consent calendar. That's Exhibit 1. The declaration of Aaron de Guzman, Deguzman declaration is Exhibit 2. The proposed findings and decisions, Exhibit 3, and then email traffic between Board Member Balaka Palan, the clerk's office, and parties. Are there any additional exhibits I may have overlooked?
No.
Exhibit, the Balaka Palan exhibit is HB1. All right, on the good cause, any deliberation from members of the hearing board or any discussion? Mr. Balaka Palan.
Yeah, I can go. This is for an interim variance, so we're bifurcating the hearing. I take it, doing the good cause portion first, vote on it, and then move on to the merits of the interim variance. So I'll proceed along that line unless you tell me otherwise. So
yeah, go right ahead.
And so they did submit the finding and decision document, and they did make the good cause finding that they're in violation of the permit, and they have exceeded the number of hours on the engine by a couple of hundred, almost 200 hours. So they're in violation of the rule 203B and permit condition number 4. The circumstances leading the violation could not have been avoided by the petitioner. It was the airport fire that occurred in early month of September. So that resulted in power loss that they couldn't anticipate or avoid it. And then the third thing was were they diligent in filing? They did file for the emergency ex parte interim and regular on September 25th. I believe they were granted the ex parte on the same date as the 25th. So they were diligent filing when they had to, and the denial of the variance would cause harm, potential cause threat to life and property, because that's it's a critical source that has to provide critical communication to first responders. So for all those reasons, I do believe we can I can find good cause to proceed to the merits of the interim variance.
Any additional comments from members of the hearing board?
I concur with the points raised by Mohan. Good cause is proper here. We've seen the situation repeatedly.
I also agree, Mr. Chair.
Same.
I'll go ahead and if there's no, I'll make the motion. If that's there are a number of corrections that has to be made, but I'll leave that for the next phase, But in this, I'll make the motion that we, in the matter of County of Riverside case number 6229-2, I move that we find good cause to proceed to a hearing for an interim variance in absence of notice to the public based on our discussion and ability to make the findings for good cause.
Second.
All right, it's been properly moved by Mr. Balaka Palan and seconded by Dr. Abraham, any further question or discussion on this particular motion? Hearing none, roll call. Actually, I'm going to call the. All right, Dr. Abraham,
Aye.
Ms. Verdugo Prauta,
Aye.
Mr. Balakaplan,
Yes.
Mr. Pearman,
Aye.
and Ali votes in the affirmative. The matter is approved unanimously. Now to the next phase, for which we'll incorporate testimony as well as other comments as proffered by members of the hearing board into the establishment of, to discuss the 6 findings, rather. We've established good cause, and we're moving on to the 6 findings. And who'd like to open up discussion on this?
I'll go ahead and do that and also make the motion later on, because there are a few areas that needs to be corrected as reference to permanent numbers and so forth. As similar to the good cause finding, we have to make the 6 findings. They are in violation of their permit condition, which limit than 200 hours. Here's where the correction, and I want to point out to Madam Clerk, they refer to permit number G7612. It should be G7611 for this location. They have a separate location that they will file separately. It's coming for consent. I don't know when, but soon. So this, they refer to throughout the document as 12. It should be 11 for that. The permit number G7611. That's one correction. So anyway, to make the findings, they're in violation of the permit, and I just cited the correct permit, that the non-compliance was beyond the reasonable control. As in the good cause finding, it was a fire and it was unforeseen and unavoidable. And they denial, and then the third, denial of the variance would cause harm to the petitioner because they are an essential communication service in that the engine provides a communication tower, power to the communication tower that's critical for the first responders. The closing and taking would be without a corresponding benefit in reducing air contaminant. The emissions are not significant because they are, one is in a remote area, 2, it's a natural gas fired engine. The daily emissions are approximately 1.79 pounds for CO, 2.52 for NOx, and ROG is 0.33 pounds. So the harm to the petitioner outweighs the benefit to public air quality. They have the next finding is whether they give consideration to curtailing operation. They have accepted the condition to limit the operation to 1 hour a month for testing and maintenance. So that basically is curtailing the operation. And during the period, the petitioner will reduce excess emission to the maximum extent possible by limiting to 1 hour. And also they will be monitoring and reporting the hours that the engine operate. Failed to mention they also requested, I don't know if they did, it's in the finding a decision, a waiver of the fee. And because they did submit the declaration of emergency under 303P, we can waive all fees. So for those, so I can make the 6 findings to grant the interim variance.
Okay. Any additional comments from members of the board relative to this matter?
Mr. Chair, I have just a few comments. This obviously was an unforeseen situation due to the airport fire over near the Cleveland National Forest going into the Lake Elsinore area. And they do provide a vital service to the public. So I also agree that the 6 findings can be made.
Okay, any additional comments?
I concur with the changes as noted by Mohan to the permit numbers, etc. We can adopt exhibit 3.
Okay, is there a motion?
All right, I will go ahead and make the motion in the matter of County of Riverside case number 6229-2. I move that we grant an interim variance commencing today. So that's a correction also that has to be made in the finding and decision document. They had a prior date, and then continuing through December 11th of 2024 for the internal combustion engine identified as in permit G7611. And then again, that's a correction. It's not G7612 as indicated. That's for the other location. And the other change, and that is at several points in the document, so that permit number has to be changed, Madam Clerk, so wherever it says one, And then I think on the front page, order granting an interim variance, I think we can remove and a reduction in excess submission fee because we're waiving the fee, so we can remove that language. And the last change I would propose, and again, minor on condition number 3, that it says a petition shall calculate, record, and report all excess submission during the variance period. And I was going to insert and submit the report to the clerk of the board by January 31st, 2025. And excess submissions are, as I had indicated earlier, while there will be excess submission, but they're insignificant. With that, I rest my motion.
All right,
Second.
second, it's been moved by Mr. Bellica-Palan, seconded by Dr. Abraham. Any further question or discussion on this motion? Hearing none. Dr. Abraham, your vote?
Aye.
Ms. Verdugo-Peralta?
Aye.
Mr. Bellica-Palan?
Aye.
Mr. Chairman? Aye. And Ali votes in the affirmative. The matter is hereby approved unanimously. The case is closed. Moving on to the next hearing. So the hearing.
Do you want to add something to? You look like you had a question or something.
I'm sorry, is that the clerk talking?
I'm sorry, don't you?
Yeah. We can't hear you, Madam Clerk.
They are filing separately for that.
Kai's asking if you can hear what you're asking.
Keep the microphone
No, I
on.
was asking about the other facility that they.
Yeah, they have, yeah.
Mhm.
So the email said that they're going to file separately for that location.
Okay.
So that
Will
will
they
handle.
have coverage? I guess my question is, will they have coverage? Or does
Uh,
it?
That I don't know. I didn't look into that, no.
Okay. Okay. Just wondering. Thank you.
All right, we're moving down to the next case, which is case number 6266-1, City of Colton, order of abatement. Who's present representing the petitioner?
Good morning, Chair Lee, members of the board. Karen Manwaring on behalf of the district today.
Who's representing the respondent?
Good morning, honorable members. My name is Wendy Wayne from the law firm Best Krieger. I'm outside counsel for the city of Colton, representing the city on this matter today.
Okay, are there any exhibits? And there was an email that was sent to the board. It was sent within the past hour, but I just wanted to confirm, are there any exhibits?
None from the city of Colton.
Okay, Ms. Manwaring?
The district provided a proposed findings decision and order, which I believe should be marked as Exhibit 1.
Okay. All right. The record is clear that would be marked as Exhibit 1.
Everyone should have gotten one in their box.
Yeah.
Box. Oh, sorry.
Hard copy.
Counselor for the City of Colton, did you receive that document?
Yes, I did. Thank you.
Okay, very well. Do you have any witnesses here today?
The city of Colton have 3 representatives here. But if the district is not presenting any witness first, what I propose is instead of having all 3 witnesses testify, is to have Carl Laney, who is the compliance, the contractor responsible that the city contracted for regulatory compliance, to speak briefly as to paragraph 12 to 15 of the stipulated abatement order, so we can get that testimony into the record.
Okay, so why do we have the gentleman to stand and raise his right hand? Or all witnesses, but specifically the gentleman who will indeed testify.
Chair Ali, just because you may not be able to see the whole room, the district's witness is currently not present in the room, and we may need to request you to administer the oath again.
Not a problem at all, not a problem. We can see, I do see you, so I see you standing, you raise your right hand. Do you solemnly and sincerely affirm that the evidence that you shall give should be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. The record is very clear. You've accepted the oath. Ms. Manwaring, the floor is yours.
Thank you, sir. Again, good members of the board.
Before you today, you actually have on calendar 2 stipulated OAs. The cases are not related to each other, but they do have similar circumstances, a down turbine. So I may be a bit repetitive in my opening remarks this morning, including the following statements. This board is very familiar with the important role that electricity generating facilities play in California to keep the power on. This board is also very familiar, unfortunately, with the many types of challenges turbine operators can face. The district works hard to work with the regulated community when they run into these challenges, and we especially do so when the regulated entity is a city, a fellow public entity like ourselves. As you've heard me say before, a stipulated abatement order pursuant to the Health and Safety Code 42451B is an enforcement tool often used by the districts when the parties agree to disagree. And that's exactly what we have before you today with the requested order. The parties have worked earnestly over the last few months, engaging in robust conversations and discussions, including a pre-application meeting that was just held yesterday, and have agreed to move forward based on the stipulated order that's presented to you today as Exhibit 1. The disagreement is as simple as this, and it's pled essentially in the order at paragraphs 10 through 13. The city understood it was proceeding with routine maintenance. The district disagreed and thought the maintenance was substantive enough to require permitting action. The hearing board need not decide that issue. What it needs to determine today is whether or not good cause exists to issue the requested stipulated order. The conditions in Exhibit 1 are straightforward, following conversations over the past few months and culminating in a pre-application meeting yesterday. The parties are in agreement that the city of Colton will submit a complete permit application within 30 days if this order issues in order to modify their current permit. The second requirement is they give us notice when they install the repaired parts and give us notice when they operate the turbine. We've also asked for some cost data related to their repairs so we can better understand it. And then the last condition is to provide notice to both the district and the clerk when compliance is achieved. Again, I think it's fairly well pled in the order at paragraphs 10 through 13 what the heart of the disagreement is, and the conditions of the order are the agreement to the path forward. If the hearing board desires to hear additional testimony from a permitting engineer from the district, we can provide some remote testimony, and it'll just take us a few minutes. But again, I think you'll find the dispute pled well at 10 through 13, and I think that the city of Colton is prepared to expand upon some of the specifics you may have questions on. With that, I believe there is good cause to issue the requested order in Exhibit 1, and I would ask that you do so. Thank you.
Counselor representing the respondent, floor is yours for your opening statements.
Thank you. I want to start off by thanking the hearing board for considering this stipulated petition and the abatement order. And I also want to extend a thank you to AQMD council and staff for their professionalism and collaborative process in bringing this issue up to the board in a very expeditious process. At issue with the plan is a power plant that the city of Colton constructed after the 2001 energy crisis in the state of California that greatly impacted disadvantaged communities such as those in the city of Colton. The city recognized that it needed a reliable source of energy without hiking its ratepayers and communities' energy costs over 800% in the span of a few months during the 2001 energy crisis. The plant's been in operation for 20 years and generally been in, the city of Colton have generally been in compliance with all AQMD rules and compliances. As Mr. Carl Lanning to my left will testify later on, there's a disagreement as to, or confusion as to whether permitting was required. But that's, as AQMD council mentioned, that's really not an issue. We're specifically requesting permission to reinstall a repaired turbine back at the plant. And this turbine is necessary for the city to continue to operate its energy plant. And more important, it's not just energy source for the city of Colton. The plant is an integral part of the regional electric grid system. And so with that, we really request that the stipulated order be approved. And before we go to Mr. Laning's testimony, I would like to also introduce two city representatives that's here today in case the hearing member have additional questions for them. All the way to the left, behind Mr. Laning is Ren Zhang, who's the Assistant Director of the Utilities Operation at the City of Colton. And to her right is Wayne Farragon, who is from the company Noresco and is the Senior Plant Manager of the AQMD power plant. And the city contracts the operation and maintenance of the power plant to Noresco. And to my left is Mr. Carl Laney, who's from the Montrose Environmental Solution. The city has contracted Montrose to support the city's regulatory compliance issues with respect to the plant. Before I turn to Mr. Laney to provide some testimony regarding paragraph 12 to 15 of the stipulated order, I just want to emphasize the city's continual commitment to comply with AQMD rules and regulations. And with that, I'll let Mr.
Ms. Wayne, just so we're clear, the hearing board is not going to question any additional individuals if they've not been sworn in. So would you like for me to perform the oath of office for all of your witnesses, including the potentials? Because we have one individual who's already accepted the oath. So will you be calling the other two individuals to provide testimony?
At this point, I do not see the need for it. However, it may be convenient if the district eventually called a permitting witness to swear them all in at the same time. But at this point, I'm not anticipating the need for it. Thank you.
No problem. So the district does not have a witness to call. So we will now allow Ms. Wayne to call her first witness.
Thank you. And thank you. Mr. Laney has prepared a quick statement and I will ask him to proceed.
Morning, honorable members of the board. The city of Colton learned that repairs were necessary to their permitted turbine, referenced as D1 in their permit. This is a singular turbine owned by the city. They do not have a redundant operation. Those repairs include replacement of stage 1 and stage 2 high pressure blades and nozzles, replacement of some other low pressure nozzles, refurbishment of nozzle segments, and finally, the disassembly of the turbine combustor to install a like-kind combustor. We all proceeded with this project under the belief that this was a routine and common repair operation. We did that based upon queries of other operators in California, the repair vendor itself, and also queried cohorts in my own company across the country who not only are permitting professionals for the utility industry, but also are former, many of them are also former professionals within the industry. Based upon all of their guidance and input, we felt that these repairs were indeed routine in nature. The repairs were critically needed at the time because without those repairs, the city of Colton faced the potential for a critical failure of the turbine. And that failure could have occurred during the summer months even when the need for the turbine was the greatest. Because we believed that the repairs were routine in nature, we also reconciled that belief with rules 1302, 2000, and 3000. Those are the new source reviews for non-reclaimed facilities, the new source review rule for reclaimed facilities, and the Title V applicability rule. In each of those rules, the definition of modification excluded routine repairs and maintenance. The district has subsequently advised that regardless of industry norms, the repairs to turbine 1 would indeed require an application to modify the facility permit. The district shared this, staff shared this with us at the back end of September of this year. And we had several meetings with staff, and it was ultimately confirmed by engineering management that everyone was in agreement that permit applications would be needed. Of course, we had already entered into or started working with district council to prepare the petition for the abatement order. That petition was reviewed by the city staff and agreed upon, and the city council filed that on October 4th. Regardless of what we believed going into this operation, we have agreed to proceed with permit applications. We had a pre-application meeting with district staff yesterday. We're all in agreement that a permit application is viable and permit modifications are reasonably expected. We have every reason to believe that we will have a permit application to the district within the 30 days specified in this order. This order would allow the city of Colton to reinstall the repaired turbine and operate temporarily in violation of rules 201, 203B, 2004 F1, and 3002C. And that operation would be covered during the time that it takes the city to prepare the application and the district to review the application and ultimately issue the permit. The operation itself is not expected to result in any changes in operating conditions in the permit or changes in the emission profiles of the turbine itself. Compliance will continue to be ensured through the continuous emissions monitoring system and relative accuracy tests on that system, as well as district specified and protocoled emission source tests for those pollutants that are not monitored by the SEMS. The city has reviewed the proposed order for abatement and advises that it agrees to the conditions contained within it. Again, we have already started to meet 2 of those conditions by having the pre-application meeting and starting on the permit application. The city and Montrose both thank district staff for their patience and their cooperation during this whole process. And we do look forward to continuing to work with the engineering staff and council as the permit application is prepared and submitted to the district. I'm available for any questions.
Ms. Wang, did you want to provide any additional questions or context, or are you okay with the hearing board? Are you okay with the district moving forward with the cross-examination?
Yes, I had 2 questions for Mr. Laney, and he answered both. I was going to ask him to testify about the outcome of the pre-application meeting and whether or not the city has agreed to the proposed order. He answered both those in his direct testimony. The district has no other questions for Mr.
Thank
Laney.
you. Members of the hearing board. Are there any questions of the hearing board? Mr.
Yes, morning, Mr. Laney. Few questions. Was this scheduled repair?
Not entirely. There was routine inspection and maintenance on the turbine. And during that routine inspection of the turbine, the potential for a failure was noted.
So was there any, in the past when we have heard of liberation of blades and so forth, did they do a borescope inspection of the unit?
I believe a borescope inspection was done.
Reveal any damage to the blades and so forth?
I don't know if I couldn't speak to that directly. I don't know that it revealed damage at that point to blades, but it certainly revealed the potential for a critical failure, like you have seen or heard in other cases.
Okay. And so when was it taken out of service exactly?
I believe it was taken out in July, late June.
But, okay. And when, do you have an estimated date when the repairs will be completed and be reinstalled?
The repairs have been underway. The repairs are actually complete, and it is ready for reinstallation.
Oh, they're ready for the,
Yes.
is the unit back at the facility?
If it's back at the facility, it's not installed yet. It was in transit, as far as I know, yesterday.
Oh, okay, so the repairs were the blades and nozzles, so some segments of the low pressure turbine nozzle, it says, and then also the turbine combustor.
The turbine combustor was replaced with a like kind refurbished combustor, portions of the combustor unit.
Okay.
But again, it's like kind. Our conversations with the repair vendors validate or confirm that it does not change the operating characteristics in any way of the turbine, nor would it change the emission profile. And it's designed specifically for this turbine model.
So I know you read and said it's part of the RR process, routine maintenance, repair, and replacement. Is that?
And the conversations I have had with various people, they indicated that combustor switch outs are not uncommon. Okay. Certainly the blade maintenance and the nozzle maintenance are very common.
If I heard you correctly, there's no standby that you could put in and you release the unit from somebody else. Is that what it is? What happened?
In this particular plant consists of a single turbine. I know that in the world of investor-owned utilities and larger operators, they have the wherewithal to actually have a fleet of substitute turbines to take care of these things. In the municipality world, that is much less likely to happen. The operators are much smaller, the plants are much smaller, and their mission does not afford them a series of plants across a large region and a high number of installations to actually make it economical to be sitting on an asset that can be switched in and out. So the repairs occur offsite, and we have these voids in service during these times.
You were able to get a leased unit, you said, it says, right?
There was a leased unit installed. Yes.
You got it from another vendor, or where was the leased unit from? And my question is, in light of the fact that this will happen routine, I mean, the blades will have, after a certain amount of hours have to be replaced and repaired and so forth. Is the intention of the city to continue to do the same, get leased unit in, or do you know if there's a discussion about getting a spare unit?
My expectation is that if this does happen again, the operation will probably be with a temporary leased unit. One of the conversations that we started with the district in permitting and that we will pursuing in the permit application process is to see how well that could be accommodated in permit language to be able to allow us to avoid the type of situation we're in today with having to get an order for abatement or a variance. And I know that we've seen similar language, again, on the investor-owned utility side of the business. But we don't know how well the district can accommodate that on our side of the business.
So I'm trying to understand the timeline. You said the unit has been repaired, potentially it may be on the side. You can replace it very soon, right? Am I correct? But now you have to wait because you have to submit the permit modification application, get approval before reinstalling it back?
That is correct. The district's position is that a permit application is required and a permit modification is required.
Do you know exactly what is going to be modified on the permit?
We don't know that any language, as far as the modification or as far as this repair process goes, we don't know how that might result in a material change in the permit. Again, we are not changing the operating conditions, nor are we changing the emission profile. I would not be surprised if the district took it upon itself to insert other things that it would otherwise do during the Title V renewal process. The Title V renewal process, things like serial numbers. And then again, the other thing we will take advantage of in this process would be to see how we can include administrative procedures in the permit for future repair processes.
Now, we have seen, I think, as Ms. Manwaring pointed out, the next case, they do have reflected in the permit other units described and with the serial number that they can replace.
Correct.
But you don't know that. You don't, the city doesn't own any. And if you get a lease, it's not owned by the city, right? So it won't be on the permit because you can be sure that you will get the lease the next time around, the same company or whoever you got it from.
That's correct. Our conversation with the district is to see how the flexibility that is currently provided for those operators that actually have a fleet of spares can be somehow incorporated to give the district the assurance it needs when that temporary replacement ends up being a leased unit instead of a company-owned unit.
So in your conversation in the permitting conference, did they, and I know, was a discussion of submitting the application, paying the higher fee for, and able to then put the unit that is repaired back in instead of waiting?
Correct. We will be submitting an application for the modification. We will be asking for expedited permitting. We will have to do a Title V permit modification. So this order allows us to have the turbine back in place and operational while all of that is happening with the district staff.
Okay, it doesn't quite, that's what I was, it doesn't quite say that, but that's your understanding that it'll allow that?
That is correct. Yes, that is my understanding. I believe I saw that in here.
I see condition to notify when it's installed, but if the understanding is you can do it while the permit has been worked on, you know, and is that your understanding? Is that what I'm hearing?
Correct. That's my understanding. The abatement order will allow us to install and operate during the permitting process.
Okay. Can you point to the language? I'm just trying to see where it says that, you know, that so that it protects both sides, you know, basically. Unless you got something in writing during the application meeting.
Policon, if I may, this sounds like a legal question and I am responsible for drafting the order. Mr. Laney's understanding is entirely consistent with the district's understanding and intention. As I look at the condition, the words "you may install" are not in here,
Right.
but condition number 2 says give us notice when it's installed. And so there's an implicit understanding that is the process.
That's the problem. Okay, we have it on the record.
If you have any suggested edits to make that clear for everybody.
Yeah, and I thought that might be better, you know, some language that they could do that while because we know that permitting, you know, the workload and so forth could take, with EPA review, will take several months or more.
Can I draw your attention to paragraph pleading 17 on page 3?
It's 17 on page 3.
The parties request an order for abatement stipulated to allow respondent to reinstall the repaired components of D1 without incurring violations of district rules while we process a permit application.
Okay, I think that's good. Thank you for pointing that out. So, all right. All right, I got no further questions. Thanks.
Are there any additional questions from members of the board? Right. Then why don't we move to closing statements? Ms. Manwaring?
Thank you to everyone for your consideration of the requested order. We appreciate your time and request that you grant the proposed stipulated order for abatement today. Thank you.
Ms. Wang, closing statements?
Thank you, honorable member. I reiterate the district council's request. Thank you for your consideration, and we respectfully request that you approve the stipulated order. Thank you.
Thank you. On deliberation, the members of the board would like to provide any deliberation.
Mr. Chair, I just wanted to go ahead and voice my support in granting this order based on the fact that all of the work that they are doing, I think they're doing their due diligence and trying to get this particular unit back in 2001 when everybody was scrambling for service, and peaker plants like this were so vital, and they still are. And especially when we hit the peak demand, whether it's during summer, but we're also finding out that peak demand is also occurring off season in what we call winter months. So, but I would be in support of this. Thank you.
Any additional comments?
Yeah, I was just going to, and I didn't ask that question, but I think what's it's different from what it was in the past was there was an amendment to Rule 219 that specifically excluded, unless it's under certain caveat, the replacement of an identical unit. So, that is what is, I think, sort of caused some of these issues to come forward, and then and reflecting on the permit like kind that you can, with serial numbers and so forth, that you can replace, because it says that replace identical unit as defined 3 that is not at a major federal source, then this is a Title 5, so is exempt from getting a permit. However, and also it says to 219(3)D, routine maintenance or repair replacement of any part that is a major source is also exempt. So if you can demonstrate if it's that under this provision that is routine maintenance, repair, replacement, then it's also exempt. But then that's a case by case that has to be worked out with the EPA and the agencies, whatever, So that's sort of what is prompting, I think, in the past, I know I've approved an identical replacement without coming through a permit, but I realized that the rule change, and EPA was specifically asked for this language to be added to the Rule 219, so that to ensure that it's the replacements fall under the routine maintenance, repair, and replacement. So anyway, so that's, and I'm glad that the agency is willing to work with, craft some language. I'm not sure how. If you don't have a spare unit, they'll give you the flexibility. But hey, things happen. Maybe they could be very creative in crafting something. So I'm all for that. But the main point is, I think, as Ms. Manning pointed out, you're allowed to go back to install the repaired unit. You don't have to wait for the permit, So, and I think, just to be on the safe side, my suggestion is you pay the higher fee you pay for expedited, the higher fee you pay, 50% gives you a temporary permit, that covers you, instead of saying for expedited, but that's up to you and the agency, how you guys want to deal with that. So I have no objections, for this order abatement.
All right, perfect. Let's move down to the motion. Is there anyone who'd like to make the motion, and then I can make it?
Yeah, I'll go ahead. So in the matter of City of Colton, case number 6266-1, I move that we find good cause to grant stipulated order abatement as set forth in the proposed finding a decision, Exhibit 3, I believe.
I'll second the motion. I'll second the motion.
Okay.
Okay, there's been a motion as proffered by Mr. Balakapalan and seconded by Ms. Verdugo-Prach. Any further question or discussion on the motion? Hearing none. Dr. Abraham.
Aye.
Ms. Verdugo-Prach.
Aye.
Mr. Balakapalan.
Oh, wow.
He really supports it.
I can see what's happening. Oh. Okay. Wow. Okay, we'll try it again. All right, Mr. Pierman.
Aye.
Mr. Pierman votes aye. Ali votes in the affirmative. The matter is hereby approved unanimously. Thank you very kindly. Now to the next case. Next case before the hearing board is Case number 623.
Chair Lee, could we please request a 5-minute break before we
Not a
resume?
problem.
623?
Not a problem. So
Thank
Mr.
you.
Day will go off the record. How about we come back at 10:30?
10:30. Thank you, sir.
For
10:30.
record. Okay, Mr. Day, it's 10:32, and we're back on the record.
Nobody's here yet, Mackay.
She said nobody's here.
Just us.
Well, then we're off the record again.
They're walking in right now. Everybody's back.
Okay, then we'll stay on the record.
Hey, was there another piece of paper? Because this continued, the exhibit A, I don't see the other. You only have one page. There isn't any, yeah.
Okay, the case before the board today is Walnut Creek case number 6230-6. Who's representing the district? I believe I see my friend, Miss Manwaring.
Good morning, Chair Lee, members of the hearing board. Karen Manwaring on behalf of the district.
Okay, who's on behalf of the respondent?
Don Barkley with York Engineering for the respondent, Walnut Creek Energy.
Okay, and I believe you have someone.
George Bianco on behalf of Walnut Creek Energy LLC.
Okay, and I assume you as well as Greg Wolf and I believe Mr. Perry will be sworn in as witnesses. Is that correct?
Correct.
Okay. Madam Clerk, just for the record, I want to simply ask again, did anyone sign in to provide public testimony?
She's not here right now,
Yeah,
Mackay.
She had to step up to get a copy made.
No problem. Then we'll go ahead and we'll wait for her return. But in the interim, what we'll do is we'll go ahead and we will perform the oath of office. Excuse me, the not oath of office. Coffee's yet to kick in. We'll provide the oath for our witnesses. Okay. All right, can you guys stand and please raise your right hand? Okay, do you solemnly and sincerely affirm that the evidence that you shall give shall be the whole truth and nothing but the truth?
I do.
Okay. All right, the record is clear that the individuals have indeed been sworn in, and we're waiting for the clerk to return.
I'm back.
Okay. How many exhibits do we have, Madam Clerk? I know there were some additional documents.
So for the petitioner, we have two exhibits. One is exhibit number one is the facility permit to operate. And then we have the findings and decision. It's number two.
No, and also this one.
That's the facilities.
That's
Oh,
the, yeah, that's the facilities,
Officer.
the respondent.
Yeah,
Yes. And then
sorry.
we have exhibit A. Respondent, which is the opening remarks. And then exhibit B is the turbine units and permitted supercore site fleet.
Okay. All right, thank you, Madam Clerk. And there are no additional exhibits, then we're going to move forward to Ms. Manwaring providing her opening statement.
Thank you, Charlie, members of the board. Good morning. As I mentioned to you before, you have two similar cases on calendar, not related, but similar circumstances. So here I am repeating myself again this morning. This hearing board is well aware of the important role electric generating facilities play in keeping the power on in California. This board is also very familiar with the challenges faced by turbine operators in our jurisdiction. Based on the number of recent petitions filed for this facility, you can probably discern that we've been working in earnest to assist this particular turbine operator to get back online. K 6230-3 was the short variance you granted in August. That was to allow temporary operation of a supercore not on the facilities permit. -4 was the abatement order that I filed contemporaneously with that in the event this board did not grant the short variance. You did, I withdrew -4. We filed -5 as a petition when the facility realized it was running up compliant with its compliance testing deadlines and needed to extend that. That variance is in place just till the end of this month. And here we are on -6, which is a comprehensive stipulated abatement order that looks to provide the facility with the flexibility that it needs with regards to operation of a supercore, while also ensuring a timeline for completing compliance testing while being in compliance with district rules and regulations. What the facility would like is to operate Unit 4. What the facility may do without an order from this hearing board is operate Unit 4 with any of the 6 permitted supercores. What the facility must do is complete compliance testing on Unit 4 with a permitted supercore in place, either consistent with permit conditions or pursuant to an order issued by this board. What this order endeavors to do is to provide the facility with the flexibility that it desires to get Unit 4 operating as soon as possible, while also being able to stay in compliance with its compliance testing. Again, as you can see by the length of time and the number of the petitions, the district has been working diligently with this facility to try to assist it to bring Unit 4 back online. This is just another example. The district often works hard to provide the regulated community with flexibility. Sometimes you see that with rule amendments. Sometimes you see that with creative permit conditions. What I'd like to point out in this is for some of the newer members of the board is that most of the district rules regulate facilities. However, some district rules regulate the district. And the primary one in mind is Reg 13. Reg 13 has some requirements, modeling, offset, backed. You need not concern yourself necessarily with that, but I just introduce it because I'm going to use the concept of backed. And I'd like to now refer your attention to the district's Exhibit 1. This is an excerpt from Walnut Creek Energy's facility permit. This is condition, I don't have the reference in front of me, E448.3. And I'm bringing this to your attention because, one, this is the relevant permit condition we're talking about, but I also want to make sure this board understands the district's thinking with regard to this permit condition. Regulation 13 says the district cannot issue a permit unless certain requirements are met. One of those requirements is backed, best available control technology. The first line of this permit condition on Exhibit 1, that in the highlighted area, only GE, LM100, PA, etc. That requirement for a specific type of turbine is how the district implements backed here. The rest of that condition is for operational flexibility. The district worked with the facility and came up with a creative permit condition that allowed the facility a fleet of supercores. A part goes down, you don't want to have to come into this hearing board to get permission to use something else. They have the ability to swap out the supercores, any of those 6. So what I'm highlighting here is that the type of unit means backed, but the fact that the district was willing to permit more components than turbines is for the purpose of operational flexibility. I've already described to you the petitions that we've had that we filed, why we're here now on 6. It's to bring everything under a single order and provide this facility with both operational flexibility while keeping them in compliance and on their testing schedule. What the order does is provides an option to the facility to temporarily use an unpermitted supercore The same thing, the same relief that you granted in your variance -3, the short variance on August 1st. This is now under an abatement order. It allows temporary use of an unpermitted supercore if Walnut Creek decides that that is in their best business interest. As I mentioned, the compliance testing must be completed on a permitted unit. So the order is crafted in a way that when a permitted unit, whether 149, 160, or one of the other ones listed in their permit is available and reinstalled, then the clock starts on their compliance testing. We have submitted to you a proposed order that is lengthy and detailed and tries to lay out the history and the facility's plans going forward, including their own uncertainty about which supercore it's going to use first. But again, the district has worked hard and collaboratively with the facility to give them a path to do so in compliance so they can get Unit 4 up and operating. With that, the district hopes that you will be able to determine there is good cause to issue the requested proposed stipulated order for you as Exhibit 2. Thank you.
Thank you for the respondent. Your opening statements, opening comments.
Thank you, Chair Ali and members of the hearing board. Let me start by stating that I have taken the oath and I'm requesting that my opening remarks be placed into the record as evidence for the matter of case number 6230-6. A copy of these remarks was provided to the clerk this morning to be placed into evidence for the respondent as Exhibit A. We would also like to submit into evidence the graphic depicting the relationship between the supercore serial numbers that are the subject of the stipulated order for abatement and the permitted operating units at Walnut Creek Energy. This graphic should be marked into evidence as Exhibit B. My name is Don Barkley, and I'm a licensed professional engineer in the state of California and also a senior engineer with York Engineering, LLC. I'm here before you to represent the respondent, Walnut Creek Energy, LLC. Walnut Creek Energy is an electrical generating facility capable of generating up to 500.5 megawatts of electricity to serve the California electricity grid. Recent upgrades to all 5 electrical generating units in 2024 successfully reduced nitrogen oxide emission permit standards by 8%, and these units are now among the lowest emitting simple cycle units in the country. On June 26, 2024, gas turbine unit 4, which is device D19 in the facility permit, tripped and was unforeseeably forced out of service and into an outage status. Unit 4 operation represents 20% of the electrical generating capacity of Walnut Creek, providing critical generating capacity at very low emission rates. Keeping it available and operating is important to Walnut Creek and to California. Permit condition E448.3, which we now have an excerpt from in front of us, lists the 6 supercore serial numbers that are permitted for use as part of the Walnut Creek site fleet referenced in the condition, any of which can be used in any of the 5 generating units. This is reflected in Exhibit B, the graphic. To install and operate any supercore with the serial number not listed in condition E448.3 would be a violation of the facility's Title V permit. To bring Unit 4 back online as soon as possible, Walnut Creek sought to identify an alternative supercore that would temporarily operate in Unit 4 during the peak summer season. When a functionally identical alternate was identified, Walnut Creek quickly filed a variance petition and was granted a short variance on August 1st, 2024. Please refer to case number 6230-3. This case was heard on consent and provided temporary relief to operate Unit 4 D19 using a borrowed supercore, which was serial number 878-187. Please refer to Exhibit B, where the serial number 878-187 is shown under the Carlsbad Energy Center, or CEC, which is a sister electrical generating facility under common parent company ownership located in Carlsbad, California. The Walnut Creek representatives were later informed that supercore 878-187 would likely not be available after all, at which time Walnut Creek continued to search for another supercore that could operate in Unit 4 while meeting all other permitting requirements and emission standards. Walnut Creek identified a possible supercore with serial number 878-119, which is part of the GE lease pool, also referenced in Exhibit B. Shortly thereafter, supercore 878-119 became a more promising option in terms of its availability. Again, please refer to Exhibit B, where the serial number 878-119 is shown under the GE lease pool. Separate from the request to install and use an alternative supercore, because Unit 4 could not and cannot be operated without a permitted or approved supercore, and compliance testing cannot be conducted without a permitted supercore, scheduled source testing could not be performed. The source testing is required to demonstrate compliance with the ammonia slip limits per condition 29.2 and compliance with initial source testing for nitrogen oxides, carbon monoxide, volatile organic compounds, and ammonia, following the replacement of the catalyst used for selective catalytic reduction per conditions 29.2 and D 29.4. An emergency variance was granted on September 20th, 2024 in case number 6230-5 for relief of ammonia slip testing requirements starting on October 1st, 2024 for up to 30 days or until October 30th, 2024. The matter before you today will bring these two variances under one stipulated order for abatement. The order will allow installation of the GE lease pool supercore, serial number 878-119, if it becomes available in a timely manner, and allow for the delay in ammonia slip and compliance source testing using a permitted supercore as required by the Title V permit. Therefore, if this order were granted, Walnut Creek would terminate the short variance granted under case number 6230-3 to install supercore serial number 878-187, as well as the emergency variance granted under 6230-5 to delay quarterly ammonia slip testing using a permitted supercore to the agreed upon schedule in the stipulated order of abatement. The order also will add a provision to allow the delay of initial compliance testing pursuant to condition D 29.4 using a permitted supercore to the agreed upon schedule in the stipulated order of abatement. We have worked collaboratively with the district council on the order, and we stipulate to its findings. This concludes my opening remarks. Thank you very much.
So just to be very clear, since the matter is indeed and in fact stipulated, will you need all of the individuals who were administered the oath to testify? I mean, this question is to the respondent.
We have here George Bianca to provide answers that the board may have.
Okay. All right, Ms. Nguyen, would you want to call your first witness and perhaps we can make it pithy since we have a stipulated agreement?
We absolutely can. In fact, I can introduce the witness and defer to the board's questioning should the board have any specific questions for this witness. We think the order stands on its own. Whether or not you have some additional questions about the background or the conditions, we're happy to answer. But may I put it to the board? Do you have questions for the district's permitting engineer?
Yes, are there any questions, members of the board?
Yes, I do, just for clarification.
Okay, thank
Go
you.
ahead, sir.
Introduce Chris Perry then. All right. The district would like to introduce Mr. Chris Perry. Chris, did you take the oath when it was administered this morning?
Yes, he did. So you're muted, Mr. Perry.
You know, he
Yes,
did, but
I
I
did.
need a verbal yes on the record.
I did.
Fantastic. All right. Mr. Perry, could you please, what is your position with the district?
I'm air quality engineer with the team that handles the power plant permitting.
All right. And how many years have you worked for the district?
33.
33 years. Are you responsible for permit applications with this facility?
Yes, I am.
Did you have an opportunity to review the proposed order and contribute to the proposed conditions today?
Yes, I did.
Okay, with that, I think Mr. Bullock-Kaplan has some questions for you, but the facility would also have an opportunity should they want to ask.
Yes.
Any questions for Mr. Perry?
We have none at this time. Sorry, we have none at this time. Thank you.
Okay, Mr. Bullock-Kaplan.
Yes, morning, Mr. Perry. Just one clarification. I know Mr. Don Buckley's statement, he did mention that condition 29.2 and 29.4, D. Now D 29.2 in the order says it's for the ammonia slip, I believe. Yet, what is the D29.4? Is that for the NOx, CO, and VOC, or what is that condition?
I'm sorry, I cut out for a minute there. I think you're asking about the condition D 29.4 on the permit, and that is the source testing condition for the initial test after the facility had replaced the SCRs. We're asking them to do test of the criteria pollutants and ammonia slip.
Is that the one, the language that they have to, within 14 days of startup, or each startup they have to do the test?
Yeah, there is a time limit in there. I think we gave them, I'm looking at the condition now. We gave them a certain time frame after they've completed the commissioning of each of the units. So after the SCR was installed and they did their tuning, et cetera, they had a certain time frame to perform this test.
Now, because we had a case where there was some issues with that language in the testing that says we have to do it within 14 days of startup. So is there a conflict with this, giving them until May 31st, 2025, depending on when they start up, of course?
Yeah. Now I'm looking at the condition, I don't see that.
Mr. Balakapan?
Go ahead.
I'm going to wait for Mr. Perry to answer, then I'm going to hopefully ask a clarifying question.
Okay, we sometimes grant an additional time to run these tests, so I don't see a conflict in this particular case.
Okay. All right. Now that's all the question I had, actually. But I do have for the respondent a question, after when you finish.
I hear you referring to an allowance to perform a compliance test within 14 operating days. And to the best of my knowledge, and I'm going to ask Mr. Perry this directly if he knows, and I believe we can ask Mr. Wolf this question also. In district rules and regulations, when we're talking about the RADA test, there is a 14 operating day requirement. I believe Mr. Balakapan would like to know whether the ammonia slip test.
No.
No? Then I apologize for misunderstanding your question and withdraw.
Okay.
Thank you. Thank you very kindly. Okay, the respondent also did not have any questions, and Mr. Balakapalan's questions were answered. So, Mr. Balakapalan, would you like to question the respondent's witness?
Unless Ms. Manwaring has any questions, I will.
The initial witness testified that he has the authority to agree to the proposed order, and that is my only question. Thank you.
Okay. Sorry, Mr. Barkley. What is the current unit, the unit 4? What supercore is in there, if any? What have you replaced it with, and how is it operating currently?
I believe I'll defer to Mr. Pianka, but I believe it has been removed.
Maybe you should introduce yourself for the record and give your name and so forth before we proceed.
Yes, George Pianka, Senior Director Environmental for NRG, representing Walnut Creek Energy LLC. We're the operator for the facility. And Unit 4 supercore that failed, that we indicated in the record on June 26, 2024, that was supercore 149, so 878-149. And from the initial evaluation, we determined that that it had to be repaired. It was damaged to the point that it would have to go off-site and be repaired. And 149 is among the fleet permit numbers.
So my question is, you came before us to get 187, I believe, and you found that's not available, right? And then you were looking at 119. So my question, what did you finally settle on, as a replacement, or is it not operating?
Unit 4 is currently not operating. It's unable to operate. And, you know, as in the record, we identified an alternative supercore. And we are also waiting for the permitted supercore 878-160 to return from its repair when it failed previously.
So your intention is to wait until that you get that back, and then you've been that is allowed in the permit, right? Not to replace it with an alternate supercore. Is that correct?
Business decision still needs to be made. We've been waiting for 878 for 160 for some time. We've indicated that you know, we believe it would be available you know, by the end of October. That said, you know, we're still waiting. And that's why we identified 119, 878-119 as the alternative. So the decision will be made, you know, based on the timing of, you know, the availability of these supercores.
Has CalISO called in the unit? I mean, it's out of operation. They know it's not in service, correct?
That is correct. It's force outage.
Force outage. So, and so far, I mean, there was no request so that you had to put in an alternate supercore to run the power at any time during this period.
Well, we recognize, you know, with 6230-3, you know, the time was of the essence with the summer peak. And of course, you know, the summer, we're now in the fall, but October continues to be, you know, a high demand. So CAISO is aware it's still in force outage and that we're seeking alternatives to support the grid.
Okay. And do you have any timeline on the 160, 149, sorry, or 160 when that's going to be coming back?
Yeah, it's regular communication with the repair facility. We understood, you know, end of October it could be ready and then shipped. It'll take some time before it gets here. But it's very fluid. We got to just, you know, continue to keep posted on how the repair is going and the availability of 160.
And typically, how many days does it take once a supercore comes back to get it up and running?
I would say typically a week for install, and then, you know, all the safety checks to make sure it's ready to be started and operated.
Okay. Thank you, Mr. Beck. I got no further questions.
Any additional questions from members of the board? All right, let's move to closing arguments, closing comments. Ms. Manuel.
Thank you very much for your time, attention, and consideration of the requested proposed finding decision and order. We respectfully request that you grant the order as demonstrated in Exhibit 2. Thank you.
Respondent.
The respondent also respectfully requests the approval of the stipulated order of abatement.
Thank you very kindly. All right, members of the board on deliberation.
I would just say that I appreciate the flexibility that the order proposed gives to the parties and also protects the district's interests. So I do find that we can support the stipulated order.
Is there a motion?
I would agree with that, Mr. Chair. The fact that the district has been very focused on working with the utility, whether it be the municipality or whether it is the standalones that still need the assistance of the AQMD's engineering department. So I want to thank both parties, and I would be able to support this. Thank you.
And Mr. Chair, I was also say I can support good cause. I was going to say they did, in abundance of caution, identify alternate supercores to install, but looks like they were not successful. But they have not run the unit actually, and I guess and the CalISO knows it's the force outage. So but however, they have contingency plan if they can. The order will allow them to install a non-permitted unit if they need to. If there's subsequent, extensive delay in getting the permitted ones back. And I think the current conditions that allow them to, to do the testing when the unit is operational, and gives ample time, regard how many starts or when it becomes operational. So anyway, so again, as I mentioned earlier, it's because I think I do appreciate staff being creative in their writing and allowing alternate units to be installed. And I think it came from the amendment to Rule 219 that because I actually allowed this facility years back to replace the identical unit without any permit. This is before 219 changed, So with that, anyway, I'll find good cause to grant this stipulated order.
Perfect. In the matter of Walnut Creek Energy case number 6230-6, I move that we find good cause to grant an order of abatement as set forth in the proposed findings and findings and decisions exhibit 2. Is there a second?
I second that, sir.
It's been properly moved by Ali and second by Ms. Verdugo-Peralta. Any further question or discussion on the motion? Hearing none. Dr. Abraham, how do you cast your vote?
Aye.
Ms. Verdugo-Peralta?
Aye.
Mr. Balakapalan?
Aye.
Mr. Pearman?
Aye.
And Ali in the affirmative, this matter has been approved unanimously. Thank you very kindly for moving expeditiously. And we will go off the record and adjourn at 11:03 a.m.
Thank you.